We've got 3 bills and a resolution on the calendar today, so I want to first recognize Representative LaHood to present House Bill 363. Representative LaHood, welcome.
Well, thanks for having me, and thanks for letting me start, as do have another committee to present a bill in. But this one is most important. This is the first bill I presented in a Judiciary committee, so, and I'm not a lawyer, don't pretend to be, but I'm passionate about this issue here. It's on elder abuse, and it's House Bill 363, and the need for this bill was brought to my attention by the Prosecuting Attorney's Council, and Mr. William Johnson, Elder Abuse Resource Prosecutor, is here with us today, and is here to answer questions if I am not able to explain enough to the committee to answer all your questions. So abusive access is a term that was dealt with a couple of years ago, and when it got its own definition. Since then, there's been one case in particular, Austin versus State, that was decided this past summer, that brought to light some confusion around how abusive access should be applied in charges and sentencing. And so what this bill does is splits the definition and makes it more clear how to be applied, so that the rule of lenity does not allow people who were charged with exploitation against an elder, that they don't get off with a lesser sentence. This puts the different types of exploitation in their proper places and allows abusive access to be a type of exploitation all of its own, instead of covering all the different exploitations that are defined in the law. Any questions so far?
Chair recognizes Representative Reeves for a
Okay.
question.
Thank you, Representative. What is the, do you know, and if you don't know this, you very well may not, I understand this isn't the normal language that you speak, but what are the lesser includeds? Is the highest degree offense is some type of exploitation of elderly, but then within that there is lesser included offenses. Do you know what those are by title?
So there's several duplicative sentencing schemes which enhance other crimes committed against elders that are going to be removed in this bill. All of those listed enhancements which should be removed are contained in 16.5, 100, and 102. And that list includes theft by deception enhancement, simple battery by long-term care facility worker, battery by long-term care facility worker, and simple assault. And just so you know my background, those of you who don't, I'm own and operate senior living communities, and so I see up close and personal, how easy it is to exploit an older adult when they're vulnerable, when they might have some cognitive or physical impairments.
So under the law right now, the elements of certain exploitation of elderly charges are the same elements as some misdemeanor offenses, and which is what's causing the rule of lenities to apply. Is that your understanding?
That is my understanding.
Okay. And is PAC, who's here to testify with you?
William Johnson.
Okay, great.
Yep.
You can come up, Mr. Johnson, if you'd like to. There may be some other questions that are applied. They could be addressed to the author. Are there any other questions from members of the committee? Okay. Chair recognizes Representative Byrd for a question.
Thank you very much.
Sure.
I am also not an attorney. But so does this mean that abuse against elderly are a lesser charge than something else?
I was a little confused by that at first myself. What this does, I'm a registered nurse. That's how I'm educated, but I'm a business owner. And so in put it in nursing perspective, if there were two medicines that could be used for the same thing, we're taking away the lesser, the weaker medicine.
Okay.
And we want the ability to apply the harsher charge and sentence to a crime when it's appropriate, when it fits.
Sure.
And I'd like to ask Mr. Johnson here to clarify that if he would.
And again, Mr. Johnson, there may be in addressing Representative Byrd's question, is that what you wanted to recognize her for?
If that's okay.
Please. Go
Yep.
Will Johnson from the Prosecuting Attorneys Council. So in essence, what this does is there are misdemeanor offenses such as simple battery of a person 65 and older where the same elements are encompassed in the elder abuse primary statute 165102. The simple battery would be sentenced at up to 12 months. The elder abuse primary statute is 12 months up to 20 years, depending upon the severity. So as it stands, a simple battery of a person 65 and older and the felony abuse would all have to be sentenced at the simple battery misdemeanor level for the rule of what we call the rule of lenity, which requires a downward shift if the elements of two different crimes are the same.
Thank you.
I've got a couple questions, but I'm going to hold off on those till I recognize Representative Reeves for another one or two.
Can you step back up? I think that it would be better for you to answer my
Yes,
question.
sir.
So does this put a new element in exploitation of elderly that makes it unique from the misdemeanors? Tell me, what are we doing here to get around to differentiate between the problem that the doctrine of lenities is giving us here?
It would be removing the enhancements in other duplicative statutes, such as theft by deception, the simple battery, the simple assault. It would remove those over 65 enhancements so that they are all contained in one statute, 165102.
So a person could still be, if a proper case was to be made against somebody for, not for exploitation, not for the felony charge, but for the enhanced misdemeanor charges, they would still, those kind of cases can still be made under, I guess, what, Section 4? Is that right?
Yes, sir. It would still be a simple battery. If, for instance, in a plea negotiation or in part of the discussion, it appeared that this was not properly a physical abuse of an elder, you could always go back and charge it as the lesser. But we cannot charge upward.
So, okay, so I think we're on the same page, but I'm not sure that we are. So if the facts are that somebody has committed a battery, a healthcare worker has committed a battery against an elderly person, but those facts do not rise to the felony crime levels, that person can still, under this structure, that person would still be able to be charged with the misdemeanor offense that is dedicated to the kind of enhancement that deals with a healthcare worker committing a battery. Is that right?
No, it would take that off. It would just be a battery.
Is that prudent? These enhancements that we've made for some of these crimes, the battery and simple battery, healthcare workers, and the theft by deception are specifically tailored to, specific industry things, frankly. And does it make sense if there are some cases that are facts, if the facts of those cases are properly set up as misdemeanors, but they don't rise to felony level, then the way I'm seeing this, you've either got a case that arises to a felony level, or if not, then we're simply prosecuting these things for just regular good old-fashioned batteries and assaults and things like that without this enhancement dealing with the fact that the victim was over 65.
Well, the enhancement factor then would be in the felony statute, the over 65. So the concern about it being done against a person who is an elder person or who is over 65 is already encompassed in the felony statute. There is really no need for the enhancement at the lower level.
And what did Austin v. State contemplate?
So it was someone who is charged with both financial exploitation under 16.5.102 by means of deception, and it was also theft by deception of someone over 65. The court looked at the newer language of abusive access, which was contained within the definition of exploit, and said that it needed to be applied to all exploitation by deception questions or cases. And so it created an extra element in proving elder exploitation under 16.5.102 that was never present going back the history of this statute. And then the court said that because those elements of financial exploitation by deception and theft by deception were the same, that due to the rule of lenity, they had to downgrade the sentence or remand back for sentencing only on the theft by deception, which I believe is 5 to 10 instead of 1 to 20.
Yeah, I'm still a little bit confused, but I will let other people ask questions.
Thanks, Representative Reeves. Any other questions? Chair recognizes Representative McLaurin for a question.
Thanks, Mr. Chair, and thanks for your explanation so far. I guess I'm trying to get to follow up on Representative Reeves' line of questioning, trying to get a sense of what prompted this and then what your action was in response. So it sounds like in that case, the theft by deception statute or the enhancement as to elder persons was at issue. Have there been any other Court of Appeals cases or any appellate case law that use the rule of lenity to collapse any of the other sentencing decisions that are contemplated in the bill?
Not in the Court of Appeals or Supreme Court, but at the trial level in the Superior Courts, yes, we have had these problems with the other statutes that were listed to be removed.
So each one of the statutes that is being touched by this bill has been litigated at least at the trial court on this issue? Rule of lenity?
Perhaps not all of them. I know the simple battery has.
Okay.
But I also spoke specifically with all of the dedicated elder abuse prosecutors around the state, and we limited it down to these that needed to be removed as in direct conflict with the elder abuse statute.
Are you aware of any cases that have gone the other way where courts have not applied the rule of lenity and have gone with the punishment under 102?
I'm not aware of any.
Okay. Thanks.
Any other questions from members of the committee? I've got a couple I'm going to raise to you. Just walking through the bill section by section, I looked at the simple assault, and as I was looking at the different elements, simple assault, simple battery has some more elements to it. Stepping back from this, there's a structural thing we're looking to address here. Has the structure outsmarted itself and in conflict with itself? And then the other question, I think, is a policy question. Simple assault, as I read it, is, the person, if they're over 65 and you commit simple assault against that person, their age, it's almost a status circumstance. That age gets you the high and aggravated misdemeanor. Is that not the case?
Correct.
Okay. So, again, as I unpack this, and these are not leading questions. These are just real questions.
Yes.
As you sort of unpack what our policy is here, I'm certainly concerned that all the members understand the policy things we're doing. I mean, if we can be very clear on the policy, as I'm so fond to say, when we're clear on the policy, the bill writes itself, right?
Yes.
But we can find the language to do it, and we can work out these conflicts. From a policy perspective, are we looking to eliminate the condition that the behavior which is defined as the elements of simple assault against somebody that's over 65, that in itself is no longer going to be a high and aggravated misdemeanor? Because my concern is we're adding things on, we're adding additional elements to that to make that additional elements to prove that up. And is that what you're trying to do policy-wise?
I'm not 100% sure I followed, but let me try.
Very clearly, there's this issue of elder abuse in an elder care setting, and there's just a 68-year-old person walking down the street, or in a restaurant, or in a convenience store, and someone perpetrates simple assault against them. Not in an elder care setting, no one that has special access to any of their resources. They threaten in a manner that would be simple assault under our law, an older person, are we going to add an extra element that's got to be proven to prove simple assault? And is that your objective?
No, because under 16.5.102, one of the other subsections, it's not in this bill, it's just one of the other subsections in it, it wasn't addressed here. Intimidation and threats against a person over 65 is already encompassed in that statute.
I hear that. I just want to.
And it's the same, it would be the same sentence in essence.
Same sentence. Okay.
A misdemeanor, I'm not 100% sure if it's high and aggravated, but across the board it is the same. High and aggravated misdemeanor doesn't change the length of time. It's still 12 months.
Well, I mean, the example I used, I think, could meet the definition of assault, but there's other assault fact patterns that might not be consistent with a threat, but could still be an assault. We need to make sure we understand what we're doing. And I'm certainly want to make sure that we don't inadvertently add elements to simple assault on somebody over 65 and not know that we're doing it. That this committee needs to know exactly what it's doing, I think, if we're going to do that.
And I don't think that would be the case, as I have discussed and worked through this with the other elder abuse prosecutors across the state, and we all agree that this would not create more burdens. In fact, it would clear up the conflicts and the burdens we currently have with prosecuting between what should be a felony and what should be a misdemeanor.
Okay. How would you characterize the difference, the different elements for us, just in summary, since 16.5.102 is not in the corners of this bill because it's not touched? What is the difference? What's the additional element of the felony?
So in felony, it is in 16.5.102 as mental anguish,
Okay.
which could encompass an ongoing pervasive mental abuse at a felony level. The more misdemeanor, the milder instances, reasonable apprehension of fear, which is the definition of assault, would probably be encompassed based on the severity of it, either as the mental anguish in the felony or in the other subsection, B or C, as the threats or intimidation.
Okay. As we step through Section 2, Section 3, simple battery and battery, could you highlight for us that being stricken, how that all comes together? Because again, as a not having the whole background on the bill until today, I'm not sure of those other code sections not in the bill that we're supposed to sort of cross reference this against. So our members, I think, for the first time are kind of getting their hands around what you're trying to accomplish.
So the simplest answer is that the definition of battery in the misdemeanor form alone is more severe than the felony physical abuse. For a battery, you need substantial visible bodily injury. So you could beat someone until they were bloody, and it's a battery. For the felony abuse in 16.5.102, you just need physical pain or injury. So that encompasses bruising, hitting.
Is that really the standard for battery, for simple battery?
Simple battery, substantial visible injury, yes. To bring it up to an aggravated battery, you would need something like broken bones or disfigurement or something like that.
Simple battery is an unwanted touching. Battery is,
Yes, battery is. Simple.
the substantial,
yes.
yeah.
Yeah, that was my,
Sorry, my apologies. Simple battery is unwanted physical touching, yes.
that's where I was going. So
Yes.
I wasn't following you there. Okay.
Sorry, I heard battery. My apologies.
Okay. Chairman Reeves, did you have a question?
Just real quick, this isn't anybody's fault, but I think one of the problems with the way that these bills are presented to us is that it only includes the language that is being changed, and this is one of those matters where, frankly, being able to reference the entirety of these code sections, at least for me, is very helpful. And a lot of times we're in room 132 where we have all the OCGA books, and so we don't really have that option right now. But I think that Chairman Setzler helped me kind of hone in on what I was trying to get at earlier. But is there anything in this proposal, and I think he more or less asked this, I'm going to ask it again in a slightly different way. is there anything in this proposal that would make a certain fact pattern that right now, as presented in our laws, is a misdemeanor offense? Is there anything that this bill would then change, and that fact pattern by operation of law because of these changes is now a felony as opposed to a misdemeanor? And I think that was what Chairman Setzler was getting at, is from a policy perspective, are we changing the result of what, I get it when you've got these consistent elements and how lenities apply, but what I'm trying to make sure of is that if we are changing kind of the base charge, of an offense that is currently a misdemeanor, if we're making that a felony, I think we just need to be clear about that and know that, and then discuss it from that level.
And perhaps we could create a balance where if the elements are different here and here, maybe we create congruity across those, so we're not eliminating an entire offense. Maybe they're balanced, or maybe we need to eliminate them. And I do want clarity, and I also don't want to toss out code sections that have been used and have become customary for law enforcement and the broader legal system. If they've been using, simple assault or battery or simple battery against a senior, we just want to make sure we're stepping with confidence when we step.
Yes, sir. So there are, if I may, first,
Sure.
There are fact patterns. For instance, a case I handled where a grandson shoved down his grandmother. It ended up with bruising on her face, around her body. She had to go to the hospital. Under this, that could be a simple battery on someone 65. Whereas, depending upon the severity, it may need to be a felony, especially since this was not his first time.
Can you, the scenario you're describing, could you charge it under the felony exploitation of elderly?
You could, and it would be sentenced under the misdemeanor.
Because, okay. And
Because
that's,
of the
okay,
lenity.
that makes sense. And I understand the problem we're trying to cure here. I completely understand the problem that we're addressing. I think just making sure that we are confident that we're doing it in the best way is what I think we need to. It's making a lot more sense now.
And to your question, Chairman, I don't think we would be setting up any kind of failures here. I have taught extensively across the state. There are mechanisms and agencies in place that teach how these statutes work, and I think we don't use these enhancements as much anymore because this elder abuse bill has been in effect, or this elder abuse statute, since 2013.
Yeah.
What we run into now is not at the front end when we have law enforcement and charging decisions, but at the back end when we come to sentencing is where we're running into the problem.
Yeah, consolidate them.
And the felony statute encompasses as well, I think I mentioned this earlier, we can always come back down and charge the misdemeanor simple battery, the misdemeanor battery or something like that. The defining difference and the overlapping issue is that over 65, which would be what kicks it from the misdemeanor to the felony anyway.
Okay.
Because that is the difference in the 16.5, 102, and 100 is that over 65 or a disabled adult.
From a policy perspective, as you move this and consolidate this in one place, do you want to have the high and aggravated misdemeanor option in this tier, or you're trying to get rid of that altogether and it to be felony land or regular misdemeanor charged under the battery or simple battery?
Felony land or regular misdemeanor, because the only difference is that over 65 language.
Do you believe there's, and again, this is a parenthetical question for the committee, is there value in maintaining a high and aggravated misdemeanor tier if it's not in a setting where some of those elements are present, but it's just a kind of that's something the committee's going to have to wrestle with?
Yes, sir.
But I just want to be clear what you're trying to accomplish.
Yes, sir.
One more question I've got for you, and there may be some others. Representative Reeves, anything else?
No, I'm good.
You referenced 16.5.102. What other code sections should members of the committee go do some homework on? Because we're going to act on this, but today I think we do need to do some homework on it. 16.5.102.
Yes, 16.5.100 that you see part of here
Yep.
contains the definitions, and 16.5.102 is the actual crime.
Because I was looking at 16.5.100 earlier. And what is there one case in particular that needs to be looked at by committee members, or is it really just a matter of looking at the statute?
Mostly looking at the statute. If you want to see the context for it, it would be Austin versus State, decided in June by the Court of Appeals. I believe I emailed Representative LaHood the case. If
Okay.
I can send it to you all, or for. Mhm.
We're good. Any other questions from members of the committee? Chair recognizes Representative McLaurin for a question.
Thanks, Mr. Chair. Am I right to understand that Section 1 relating to simple assault is likely to, and I guess merge is not the right term, but you take it away and 102B would apply, and you may have mentioned that earlier, the intimidate.
It could easily apply, or if it's still a simple assault, it could be a simple assault.
Okay. And so we're not expecting Section 1, the simple assault crime, to be bumped up to felony liability under 102.
No.
It's just the theft by deception, battery, and simple battery. That
If simple assault is in felony land, it would be under 16.5.102, the top subsection A, mental anguish.
mental anguish. And that would be the deciding element for whether.
Yes,
Okay.
which appears more as an ongoing pervasive. You could equate it kind of to the child abuse, mental anguish type statutes.
Okay. But your understanding would be that the other three crimes should have followed more closely. Remdesivir, or is it just newly added to the dangerous drug list, if you know?
Yeah, I do not know, frankly. And just for the record, the Georgia Pharmacy Association, this is something that we watch closely. This is not a Georgia Pharmacy Association bill, but for our members, obviously, it makes sense to see the federal and the state kind of come into compliance. And so this is a bill that we see every year that looks to do those things. But in terms of that specific, I apologize. I don't have
No
a
problem.
really good
I
answer
was
for
just
you.
excited I recognized anything in this bill. So,
Don't ask me to pronounce anything.
right. Thank you.
I'm not going to ask you to pronounce anything because I'm going to ask Representative Smith to do that. Sometimes we have the author, but in this case, the author wasn't here, so I said I can have a freshman on the committee pronounce the drug we're adding on line 80. It says 69.105. Could you pronounce that for us, Representative Smith, as a learned attorney? You're on.
Ava Pritanib.
That was my reading of it. Do we have consensus that it's avaprintinib? Is that where we are on line 80? Okay. Okay.
Ava.
Thank
Ava.
you. Yes, indeed. Yeah, I'm going to be kinder than that, but I appreciate the Senate.
Chairman.
What's the pleasure of the committee on HB 367? Do pass second. Any discussion? Hearing none, all those in favor of sending HB 367, LC version at 480323 without any amendments forward with a do pass recommendation, signify by raising your right hand. Thank you. Thank you, sir. Thanks for being with us today, and we stand adjourned.